write a note. That would be a delightful thing. We've all run into the question of whether or not cell phones can be tracked. We've run into it daily, hourly. We all want to know.
Okay, we're going to have to take
Can we be tracked? I'm not sure we can be tracked. Not only can our faces be ID'd, but his camera can tell if we're smiling. That's not a joke. But smile detectors work. Aaron Romano. We're very lucky. We're very lucky. I'm not going to read it all. I'm going to hit highlights. I want the time for him. Law clerking at the Pennsylvania Supreme Court for the Honorable Russell Nigro. Did I pronounce that right?
Nigro.
Yeah. Nigro. Currently managing, let's get to the important stuff, currently managing his law firm in Bloomfield, Connecticut. These are the things you need to remember 6 months from now when you're thinking, who's that guy that was so impressive, and boy, I need an attorney in Connecticut. I know he's doing this for his health, but I'm putting in a plug for the fact that he may be working for a living. I know some of us are. Mr. Romano,
yes.
Thank you.
Lenny, thank you very much. So, good morning, everybody. My name is Aaron Romano. I want to tell you how honored I am to be here. This is my third NORML conference. My first one was Aspen last year, and it was eye-opening. For those of you who are here for the first time, I hope it is an enriching experience for you and that you continue coming back. Now, I developed this PowerPoint because I found that I was having cases involving historical cell phone data. And what the cops are trying to do and what the prosecutors are trying to do is show where people were based on the cell site, or what is commonly known as cell towers, but we're going to get away from that. We're going to use cell site, but where the cell sites are that your phone pings off of, so they can go ahead and place you in a certain place. A lot of attorneys, when I first found out about this, I thought, wow, this is a great tool because I can use this as alibi. But really what's going on is in the course of getting discovery, you're getting these historical data sheets that talk about where the cell phone was and put your client at the scene of the crime. So I had one of these cases, a home invasion case in Connecticut, and I looked for resources. There was no place that I could turn to. I hired an expert, and with the expert, we came up with a good cross-examination for the government's expert and came up with a way to debunk the prosecutor's version of how they use, and their theory is how cell site pinging works off of cell towers or cell sites. So I'm going to go through this just like I would with a jury, and the juries understand it. That first trial that I had that involved cell phones was a 15-week-long trial that ended up in an acquittal. And when I spoke to the jury afterwards, they said that the cell phones evidence was a large part in the consideration that they had in acquitting my client at the end. So if I could teach a jury, I can teach you guys. Now there is some math, there is some science involved, so we're going to take it slow for those slides. And the materials are included, I believe they are included in the disc. So if you ever have any questions, you can reference the disc, pick up the phone, call me. I walk attorneys through this all the time, attorneys from all over the country. And hopefully they're doing well with this. Okay, debunking cellular cell phone tracking, how to make the prosecutor cry. So first things first, ubiquitous usage. Over 80% of the US population uses cell phones. That's a site. And in July 2012, a congressional inquiry found that telecommunications carriers last year fielded 1.3 million requests for subscriber information. That's the degree of investigation that law enforcement is going into to find out what people's cell phone records look like. Okay? Be aware, we're not going to cover the following topics. Motions to suppress. You have to be aware of these cases, though, because if you have a cell phone case, you need to look at this stuff. Okay? This is a whole different day or a whole different presentation. U.S. v. Jones, U.S. v. Skinner, warrant issues. You've got to be aware of these. These are the relevant statutes, okay, that you need to look at, and court orders for real-time tracking. Now, Anyone recognize this? No one? Okay. This is Galileo on trial in the ecclesiastical court. Now check out Galileo. How many of us find ourselves in court saying, well, Judge, we all know that the sun is at the center of our solar system, and everyone's mocking you and everyone's laughing at you. You know you're right, but everyone thinks you're wrong, okay? Being a lawyer, and many of you know this, and for those of you who are new and you're getting into criminal defense or you're getting into medical marijuana advocacy, being a lawyer in this field is one of the fields where you have to become comfortable being uncomfortable, okay? Now, this is what we do every day. In Galileo, I put this in here because this is a scientific, he had science behind him. And what we're going to do with this PowerPoint is we're going to use science and the scientific method in our favor to debunk cellular site trafficking as the prosecutor presents it. Today's topics: identify the issues in cellular telephone cases, understand the mechanics of cellular phone tracking or ping from the prosecutor's perspective, destroy the evidence via pretrial motions and or trial, and the goal is to prove that cell site tracking is unreliable or junk science. So if all of you go back to your respective jurisdictions, use the motions that I have included in the disc, and you challenge this, and you make these challenges in advance, and you keep this evidence out, this is the impact litigation that we can get involved in on a case-by-case basis, and we can ultimately have the courts keeping this stuff out, okay? And far too many clients are getting convicted because of this weak evidence. Historical data versus real-time tracking. We're going to cover the difference between the two, but first we're going to cover historical data. So, how does the handset connect with the site? So here you have the handset, you have the cell sites. They're called cell towers here, but we're going to use cell sites from now on. Cell phone is looking for a tower or a cell site to connect to. Any one of these can service this handset. A connection is made. It goes to a switch box, okay? The switch box then connects it to a landline. And if you're calling a landline, it sends that signal over to the landline, and another person picks up. If it sends it to another cell site or another cellular phone, what it does is sends it in a cellular network, and then it connects with that other phone that's connected to wirelessly with another cell site. Now, this happens in a matter of like microseconds. You connect calls and it doesn't even take a second, and that call is connected, and all of that information is being exchanged. That's how brilliant this is. So the prosecutor's assumption is, very important, cell phone uses the closest cellular site available and therefore can be used to accurately track the user of the handset. That's the whole premise, okay? The guy's at that, he's using that cell site, using the side of that cell site or that cell tower, if it is a tower. So he's got to be there. That's the closest cell site that was available to the phone, and that's where he's got to be, right there. Not true. Scientific challenge will prove. Does anyone recognize who that is? Very good. Thank you. Okay. Cell phone records are an inaccurate means of tracking the handset's movement. Science is your friend. I know we're all lawyers, but we have to get used to this, okay? We're going to use this in our favor. Science is your friend. Let's take a look at the government's evidence. You're going to get something called a call detail sheet. This is a call detail sheet, okay? Has the call, this is the number that is for the call detail sheet, the telephone number right here, the date that the call was made, when the call was made, how long the call was in seconds, whether it was an inbound call or outbound call, okay, whether or not it was forwarded, international. Now, if it's an outbound call, you're going to have a different number because it's going to be the called number right here, okay? The calling PTN is that's the number. If it's an outbound call, it's always going to match up. Oh, actually, the call number right here, the calling number is that one, okay? This is an inbound call. So this is the number calling into the phone. On an outbound call, you have the number here, 218. The calling number is 218 because it's really calling out to this number. Now here's the important part. Here's the meat of what we're talking about here. Originating cell site and terminating cell site. So you're going to have a series of numbers here, and these are codes to identify the cell site that the cellular telephone or the handset connected with. What it's going to tell you, you're going to be able to cross-reference this because in your discovery, you're going to have a book, a master list of the cell sites in approximate locations, approximate street addresses, and latitude and longitude. It's going to tell you the side of the cell site, and it's going to tell you which cell site. It's also going to tell you which switching station it used. Here we have switching stations identified in New York. And this is a Connecticut case. So the switching station, you have to understand, so in microseconds, these signals are being sent from Connecticut to New York to make the connection for another call in Connecticut. Okay, and that's how the feds get involved with many cases, because these calls are going over state lines. So I received this too. These are maps, and so you'll have some conclusions made by the officers over there. And what they'll do is they'll chart out where the cell site was and where they're predicting your client was. So you can kind of see here, they gave me several of these to scare me, to make me think that they've tracked my client successfully back from the point of the robbery back to his house. This is a summary that a prosecutor prepared in a case that I had. So this is a summary of the cell site locations. So what we have is we have the cell sites over here listed by number, the latitude and longitude, the street address, the city, and then the approximate distance from the incident. Okay? And that's a summary that was prepared by the prosecutor in the case. This is called a propagation map. We'll get into why this is very bad, and if you get this in your discovery, I'm going to tell you how to keep this out. These are some cover sheets that come with the cell records that you're going to receive. You normally receive them on a disk, and so these tell you, they give you a quick diagram of the cell site and that kind of thing. This is another version, a different provider. This is their call detail sheet. Pretty much the same information. Calling number, call number, the dialed digits, okay? Inbound or outbound, start date, end date, duration in seconds, repull number, which is a switching station, then first cell site and last cell site. And the first digit here is actually the side of the site. So 2 is whatever side 2 represents. And this was site 39, okay? So the other thing you're going to know about your handset is whether or not it's a contract or prepaid or pay as you go. And we're going to get into how important that is with your case too. So experts, you're going to also know who's going to be here for your experts. Well, are they going to be law enforcement? Are they going to be someone from Sprint University? Are they going to be the hired gun? And you're going to also know about the cell phone itself, and this is very important. So all of these things, when you have a cell phone case, you should be looking for in your discovery. If you're missing something, you've got to go ahead and ask for it. Now, how does the cell site work? Typically, there are 3 sectors, each using a different frequency, north, south, east, southwest. However, a cell site may have up to 6 sectors, and often multiple cell phone providers will rent out space on the same cell site. This is a typical pole over here, and there are different cell sites here, okay? Multiple providers have antennae fixed on this one pole. They're all sharing it, okay? And providers can share the same antennae too, or so-called like the bandwidth, if you will, the capacity for those antennae to exchange information. And sites can be omnidirectional. So just in case no one knows or someone doesn't know what omnidirectional means, I like to do this for the jury, because I like to get around, walk around in the courtroom. Omnidirectional, you just go like this, omnidirectional. And then they get it. Because, you know, jurors, they don't read about, you know, Latin prefixes and that kind of thing, at least in my jurisdiction. So types of cell sites. You'll find them on buildings. You'll find them mounted on telephone poles, on tops of buildings, disguised as nature. That's right. So, cell phone as a location device. Prosecutor claims your client was at the crime scene based upon your client's cell phone records. What do you do? Remember, first line of defense, people, the prosecutor must first establish that cell phone belongs to your client. Don't make this part easy. And then, secondly, attack the science behind cell site tracking. Okay? Cell phones are not tracking devices. Remember, cell phone companies are not in the business to help the police track criminals. They want to ensure maximum coverage to their consumers. This means that many cell sites, now understand this, many cell sites have the ability to connect to a single handset. Keep the customer satisfied. See? No drop coverage. Okay? What you have is driver, handsets on. Multiple cell sites serving the driver, the handset, at the same time. Because as this person is traveling, you want to ensure that the call isn't going to be dropped. What's going to happen when calls get dropped? People are going to drop that provider and move on to the next one. That's why they have multiple sites serving a caller at the same time. Therefore, coverage must overlap. The government's theory are cell phones are two-way radios, and the handset seeks a site in the network with the strongest signal, usually the nearest available site. If the nearest site is unavailable, the phone seeks the next strongest signal, usually the next nearest site. Here's an alternate theory, and this is the theory that my expert puts forth when I put him on. The handset picks the cell site that has the least amount of traffic. Because traffic is one of those factors that will bump a cell call off an antenna. If there's too much traffic, like bandwidth, or too many phone calls being routed through a particular site, calls are going to get dropped. So what his theory is that the switching station, the call gets routed through the switching station, and the switching station itself chooses which cell site to use. That's not the government's theory. The government's theory has to do with nearness or closeness, distance, and strongest signal. So for now, what we're going to do, if you don't have a defense expert to come in and give this alternate explanation, we're going to use the government's theory, and we're going to destroy it. Typical case, cellular telephone records place your client at the scene of the murder. Client story, SOTI. Anyone know what this stands for? Yeah, you know, I didn't know that. I just learned that recently. So, some other dude did it, okay? All right. But my guy puts himself at the scene. So why bother with all this, right? You have cell phone records, my guy gave a statement. So what do? Gain credibility with the jury. Use your litigation of this because you're going to be right. The expert will have to agree with you on these points, and you're going to showcase how smart you are. So instead of going through a train wreck trial where your client gave a statement and all this other stuff is going on, finally get up there and gain some credibility with the jury. They'll hear that expert agree with you during your cross. Showcase your winning personality and scientific knowledge. Okay? So during a typical trial, what are you doing? You're jumping up, you're objecting, you're asking leading questions. You know, it's a very frustrating thing. Now what you're doing instead is you can bring this witness to you, and you're not in necessarily an adversarial stance. It depends on who's testifying, of course. But you can go ahead and now have someone agreeing with you instead of someone saying, no, that's not the way it happened. Destroy the expert by making him agree. Okay? Your weak defense now becomes credible. So if you had one of those train wreck cases, okay, and now you start to gain credibility on this one topic, and you do have a defense, now you've gained credibility. If you had not litigated this point, you'd be at the same spot without gaining any credibility with the jury. They wouldn't listen to you. They wouldn't hear an expert agree with you. Okay? Confuse the prosecutor. That's my favorite. Throw them off your trial strategy. Make them work. You know, prosecutors are just like dogs. I mean, you can take a ball, you throw it this way, they chase it. You throw it that way, you chase it. As long as you know where you're going, okay? And they don't. They think this is the crux of your whole case. You're golden. Make them work. Now, I love to use this. Closing argument. Why is the prosecutor using junk science if their case is so strong? All right? So you've destroyed this whole cell phone evidence, and now you've spun it because how is it even relevant to the case when your guy gives a statement? Okay? Why would the prosecutor even bother bringing this evidence in? And never, ever, ever underestimate the creativity of a jury. I've spoken to jurors after my cases, and they come up with the wildest ideas about why my clients are not guilty. So I urge all of you to litigate issues, not just this one, but if you have other motions to litigate, do it. And even if they're not motion, you're doing it in front of the jury. Go down that line of questioning. Give the jury something to chew on when they go back and they're deliberating. Okay, defenses. Who had the phone? Prove the defendant had the phone at the time. Was it a shared phone? Okay, what do I mean by that? How many of you have the stolen car cases where the guy trades the car for crack for the weekend? Okay, it's really not stolen, it was a business deal, but then, you know, the guy whose car it was who got the crack reported stolen, and your guy's defense is, oh, it was just, you know, for a couple bags of crack. Phones are used just like that. They're just like currency. And people will buy phones and trade phones to use those phones for crack, for drugs, for money, just for the weekend. Typically, a drug dealer who wants to go ahead and change phones or change numbers will go ahead and use different numbers. He'll go to his pager, one of his customers, and give them a couple bags of crack to go ahead and use that phone for the weekend so they can set up shop and then return the phone. What do they care? As long as they can go ahead, make those sales, and then move on to the next phone, I guess. Determine if people in the records know the defendant. Should they testify? Determine if people in the records had contact with the defendant via the telephone, day or name. Examine the client's phone contacts available, nicknames for telephone numbers. Now, let me tell you how this plays out. I had a case where the issue was, and I made an issue of this, of whether or not it was my client's phone. Typical scenario is what I just described to you. So, what did I do? I took a look at the call detail sheets, I took a look at those telephone numbers, and I called them. Do you know my client, Twan? No, don't know, never heard of him. Now the issue was here what my client's nickname was, Twan or Tone. It turned out that the people who were called that weekend were called by someone named Mark. Now there was never an issue about a Mark being involved with the case, but a Twan or a Tone. So what I was able to do is get a photo of my client, take it over to the witness. Have you ever seen this guy? No. That's powerful evidence to come back and bring to the jury. You bring that person in, you receive telephone calls from that number that the prosecutor just made a big deal about. Yeah? You ever see the guy sitting next to me? No. Do you remember receiving phone calls from that number? Yes. Who was that from? Mark. Now what do you think that did to their case? Okay? Now look at the contacts. If you can get the contacts or the phone from that other person, look at the contacts that match up with that number. You'll see that there will be different nicknames. In this particular case, the nickname for that person and supposedly my client's number wasn't Twan or Tone, it was Mark. And you can confirm that. So you can use that physical cell phone and say, look, you bring the person in, do you have your cell phone with you? Yes. Have you changed it? No. Can you go to the contacts for that number? Yes, you can. What does it say there? Mark. Okay? Now, contract versus prepaid or pay as you go. Don't let the prosecutor say prepaid phone is a drug dealer phone. Okay? Everyone understand the difference between prepaid phones and contract phones? Okay, you can go ahead, you can take out a contract and get a free cell phone. Okay, free iPhone or $100 for an iPhone. You sign up for 2 years with some different providers. Okay? The other way to do it is to pay full price for the phone and not be involved in a contract, but pay it month to month. Month to month service is much cheaper than the contract. Okay? See, what you do is you bring in this. Simple economics. It's the fastest growing market. Okay? Money savings for prepaid. 2008, about 50% of new cell phone users signed up for prepaid cell phone service. The next year, in 2009, about 80% of phone subscriber growth came for prepaid. Industry predicts 1/3 of cell phone users will be prepaid by mid-2013. Prepaid cell phones make up 25% of the cell phone market. And check this out. More than 1 million wireless subscribers in Chicago are on a prepaid plan. Now, I was just about to say, I'm in Connecticut. I'm in the wrong place, man. I got to move to Chicago, so make some real money.
Aaron, after that discussion about business law, should we lawyers get those prepaid phones?
I had a prepaid phone for a while. The difference between the prepaid phone that I had, there was a difference between the service. The service I had was Boost, which is a subsidiary of Sprint, and the Boost phones didn't have the diversity in terms of being able to connect to the different cell sites. Sprint has an agreement with Verizon, so if you are signed on as a Sprint customer, not a Boost customer, your Sprint phone, if you're out of range of a Sprint cell site, will connect with a Verizon cell site because they rent out space, like I mentioned before. But if you go with a cheaper plan like Boost, you're just in a dead zone and that's it. And so I wasn't able to get calls in the lockup, in my local lockup or in some courthouses because the way things were. Now I have Sprint, so I can go ahead and make those calls where I need to. So, who do we have here? One of our favorites here.
The doctor.
Yes, okay. Hunter S. Okay, prepare for battle. This is what we're going to do. Only you can make the decision about how to challenge the evidence. Pre-trial versus trial. There's no doubt that cell phone site tracking is an inaccurate method of locating the handset. Do you want to raise it by way of a Daubert hearing, a pretrial hearing? Okay, these are decisions you have to make. U.S. v. Evans, it was granted, and that decision is in the materials in the CD. Say v. Davis, denied, and that was mine. But it didn't matter because I won the case. So this could be a good opportunity to get discovery in a trial run at the government's expert. Okay, so I like to use pretrial motions, even motions to suppress or dead dog losers, as a preliminary hearing for my trial. Okay, for those of you who live in jurisdictions where you don't get a preliminary hearing, go ahead, file that motion to suppress, litigate it, get the information you need, lock in the cops. They're thinking about motion to suppress. You're thinking about trial strategy, so you lock them in. They're thinking something else, okay? So it's a good opportunity. If you don't think the judge will keep out the cell site evidence, you may not want to reveal your strategy pre-trial. So don't, keep your cards close to your chest. You don't want to show them everything you've got, okay? Uh-oh. Should you retain your own expert or simply destroy theirs? My preference is not to present an expert, but to have my expert there to listen to their expert to help me prepare for the trial and to help me build my cross so I can get better holes in their case. Potential legal issues. Is the evidence relevant? Is the maker of the call provable? Is the probative value substantially outweighed by the danger of unfair prejudice, confusing the issues, or misleading the jury? Are they going to allow lay witness testimony? So you have to figure out, okay, this expert's testifying, are they a true expert, or are they just a lay witness who is interpreting these records? If an expert is required, what is the expertise? Now, this one's a little more complex, but we'll get into this later. Given the potential unreliability inherent in opinions as to handset locations based on stored cell site data and the disparity in accuracy using GPS or trilateralization type methods, are such opinions admissible? We'll get to that. You'll understand that by the end of this, okay? And see, there's a law review article, if you need a very cursory review of this, by a gentleman named Aaron Blank, and you can just Google his name, and this law review article covers some of these issues in a very cursory detail, so if you need a refresher, I recommend that you go ahead and check that out, okay? First line of defense, object to the expert, okay? Voir dire the expert. I love voir diring experts because you can ask so many ridiculous things. Challenge their expertise. Did they go to Sprint University? How about the memberships in those professional organizations? If you have a CV in advance, look up those memberships, find out how you can join. Because if it just costs $50 and you join, then you can go up there and say, oh, sir, you're a member of this prestigious cell phone industry organization. Is that the one where you send in the $50 and you get the certificate for the wall? Oh, what do you mean? Like the one that I've got here. So look up the memberships for articles. This I love, okay? Because you can prepare for learned treatise exceptions for trial. Get in order to adopt the qualifications of the author of the treatise. One of the cases I had the CV in advance. I looked up the organization that he was a member of, and I found that there were articles that supported my contention that cell sites were an inaccurate means to place someone at a particular location, and GPS was more accurate, okay? So what I did was I had this guy on a pretrial motion, he had no idea I had the article, adopt the fact that this industry publishes articles for the FCC for review, and they are experts, and they are experts in their field, and that their opinions are accurate. Okay? So then I banged him at trial with this. And the learned treatise is something, it's one of those most unused exceptions. If you have an expert, do your homework, get a learned treatise, because what ends up happening is that learned treatise goes back with the jury during deliberations. It is part of the evidence. You move it in. So they forget about the expert's testimony. What they have in their hand is the opinion that you want them to make to the evidence, okay? Have your expert present at the pretrial hearing. You may or may not want to present him or her, but they can definitely assist you in prepping, okay? Now, methods of cross-exam, pretrial motion, intimidate the witness. I love this, okay? Why intimidate the witness, okay? Why? Make them cry if you can. I treat expert witnesses like child witnesses, okay? You use your facial expressions, use your demeanor to go ahead and frighten them. It is a very frightening experience to take the stand. I recently had to take the stand on a habeas case, and it's funny because my former client actually said, no, he did a very good job. So, but it was a nerve-wracking experience for me to sit up there and be a witness. I've been litigating in court for 15 years. I've tried over 1,000 cases. But I never sat in a witness box. And all of a sudden, sitting in that witness box, I was shaking like a leaf, okay? Imagine an expert. You're going to go ahead and cross-examine this expert on their credentials. They are shaking like a leaf in there. Use that to your advantage and scare them, okay? What you do is you're angry when you get answers you don't like. And then you're nice when you get answers that you do like, and you give them softball questions, and then you just like, come to Papa, I'll get you out of here, don't worry. What? You know. And then like a child witness, the same thing you do. Train the expert, okay? Give them a positive reinforcement, negative reinforcement while they're up there. And prep the use for your own expert. Now, trial, different strategy. Be nice. So that same expert who you were not so friendly to before is now cops an attitude with you, and you're just the most pleasant of individuals in front of that jury. And when that expert starts giving you those cutesy answers, you just look over at the jury and just, where's all this hostility coming from? Use the expert to showcase your expertise, because you know what? It's really not about the expert. What you're doing is you're selling the idea of your client being not guilty. You want to do everything you can to make sure that jury's not looking at your client, because I don't know about the clients that you've got. But when I saw that slide of EX's client, that's my typical client too. I mean, you know, they just sit there all thugged out. I say, come on, guys, you know, you got to bring your shoulders in a little, put your hands in front of you, you know, look like a little mouse. And they can't do that. They just have to spread out, just kind of like, yeah, this is all right. Or they're sleeping. So, okay.
That's better than the spread.
Yeah, right. Get them to agree with the softball questions. Educate the jury. This is so important, because you're not just cross-examining, you're educating the jury, okay? Your cross-exam questions are statements, but you're going to pose hypothetical questions to this expert, showcase your knowledge. This is going to be the first time in the course of the trial that you will be able to engage the jury, aside from voir dire, which is going to come up, which is a very important aspect of the trial. But now you've got an expert. You're smarter than the expert. And you're going to engage that jury and teach them. Okay? They're not going to just passively sit there and listen to people testify. You're going to engage them. You approach the expert. You're now in the well of the courtroom, okay, and walking around. They're watching you. Okay? Be the teacher. Use demonstrative evidence. I use, when I have my experts, I use an easel, marker, and paper, and that's what I do. Okay? And ask your questions from general to specific. Challenge the assumptions. Teach your fact finder. Cellular records can only tell you how the call was made, not where the handset was. It can only tell you the means within which that handset connected to a site and effectuated the call. The area within, this is very important, okay? The area within which the handset made the call to the site is too large to pinpoint the location of the handset. So we're going to get into the first line of defense for the technical aspect of cell phone site litigation. First, we have what? We've got, he didn't have the cell phone. Prove it. Okay? Now we're going to get to the scientific part. It's too large. The area is too large. Just remember that. Area is too large. Okay? And the strongest signal is not necessarily the closest site. Cell coverage in theory. Okay? This is cellular aspect. This is a site. These are the sectors in the site. The cellular aspect relates to the system of cell sites or towers, whichever covers cells. Okay. I still draw my diagram like this because it's easy for the jury to understand, but you're dealing with different sides of a cell site, so these are going to be the different sectors. You just have to know that that's how it works. Okay? These are some, okay. Math people, okay? Cell site. So, we're going to find out the range here. Assume it's omnidirectional. That means 360 degrees. The radius is 10 miles, okay? How do we find the area? Pi times r squared. 3.14 times 10 times 10, 314 square miles. That's the range of this particular cell site. Now, where did I get this number? Well, during the course of my litigation, I've asked experts, what is the average range? They say between 2 and 10 miles. So I took the 10 mile because it's easy to go ahead and do the math for the jury. Now, once you start going ahead and you use this in front of the jury, you pose the hypothetical, okay? Would you agree with me, sir or ma'am, that this would be the formula in order to determine the area of the cell site? They have to agree with you. All of a sudden, the jury is taken back to high school, where they learn geometry. Okay? Now, for many people, high school was a really, really fun time. For me, it was not. But for those who it was a fun time for, they're going to take a look at this and they're going to harken back to those glory days, okay, where they were the captain of the football team, okay, and they're going to they're going to lean forward with interest, okay? And this happens every single time I start going through these mathematical equations, okay? Now, relax. Relax, man, okay? I know this math is complicated, but we'll do it again, okay? Here's the math. Okay, math 101. Area of a circle, area equals pi r squared, radius 10 miles, 10 times 10 times 3.14, 314 square miles. So, even if it's a three-sided site, and the direction is known, so we look at the cell site, we look at the call detail sheet, and we can say it's one particular site. You take that 314 square miles divided by 3, and you're still talking about 104.67 square miles. Do you know why this number is important? Because what you're saying is, your guy, if he had the phone, is somewhere within 104.67 square miles. That is a huge area. So how can they say with any degree of certainty that that handset was at the location of the crime and not at an infinite number of other locations within 104.67 square miles? So what I like to do is I like to make the number even bigger. Okay? Math 102. Acres. Now if you live in a place where you have homesteads that are divided up in acres, 1 square mile is 640 acres. So 314 square miles equals 200,960 acres. Okay? Square feet's my favorite. Because, what are we talking about? We're not talking about locating a battleship, we're talking about a handset. We can all agree, for argument's sake, that my handset will take up 1 square foot of space. Okay? But, once you find the area of coverage for that cell site, let's do this. Let's just talk about 1 square mile. 27,878,400 square feet. Those are different locations where that handset might be in 1 square mile. If the handset takes up 1 square foot of space, there are 27, again, possible locations within that 1 square mile. Within 314 square miles, 8,753,817,000 possible locations. The bigger the number, the more you make your point with the jury. Okay? Again, yeah?
Google says Manhattan is 33.7 square miles.
Yeah, we'll get there. I'm going to get to that. I have a diagram that I use to show exactly what this area looks like. Okay? The range of the site is too large, this is the whole point, to pinpoint with any degree of accuracy where the handset is located. And after all, that's the whole point of entering in those cell site records, those cell phone records. So the possibilities are endless, okay? Just think, average homestead, 1/3 of an acre, 602,880 potential occupancy locations, plus the roads and yard spaces in between. Now, my favorite is in an urban area. So you're not even talking about area now, you go up because you have apartment buildings. Now, just assume 10-story apartment building with 10 units per floor. Increase the number as much as you can. If you're in an urban, highly dense area, go ahead and use that to your advantage, okay? All right, so here's NORML's headquarters. This is a 2-mile radius diagram, okay? So assume the cell site can travel to 2 miles. That's what it looks like. Now you see the 2-mile within the 10-mile radius. Now you see 31.2 miles. This is what my expert says a cell phone or cell site can, the maximum coverage or the maximum point of coverage is 31.2 radius, and this is what it looks like from outer space. Pretty big, okay? It's huge.
Wow.
If you take that 31.2 square mile figure, that covers the whole state of Rhode Island. All right, so defense expert, here we go. Cell tower signal can reach a total of 31.2 miles, and that's what he testified in my trial. How to create the map? This is how you do it. Use Google Earth, and you use this website here. So you can do that for your case. Now, what I enjoy is getting the prosecutor to finally skate on my pond. So once you go ahead and you start with this course of cross-exam, you'll see what happens here. Now, this is a case where I litigated a pretrial motion. It was denied. It was a Daubert-type motion to keep out the evidence because I challenged the accuracy of it. Yes?
On fine law yesterday or day before, I
saw a case, I think it came out of one of the circuits, where they ruled that it was bullshit.
That's right. That was U.S. v. Evans. And so that opinion and the motions before that opinion was made, they should be contained in the materials as a PDF on the desk for you. Okay? If they're not, contact me. I'll send it out to you. So what we have here is the redirect from the prosecutor. And here he goes. And we talked a lot about attorney. So background. I litigated the pretrial motion. It was denied. Judge said it's coming in. Now we're in the middle of trial. I crossed the expert. This is the redirect. We talked a lot about, Attorney Romano has talked a lot about locating person. Fair to say that a person strikes a tower, the only thing you can really say is that they're within the range of the tower. Yes? To know exactly where they were, you'd need more information. That was my whole point of my pretrial motion. And now the prosecutor is getting the expert to say that. Now, in hindsight, I think what I should have done, and if you're ever in this situation, what you need to do is say, Judge, I renew my motion. I didn't do that for this case. Now I can look back and say I should have done that. Okay? Now, this is really important. So I get my recross. What are the ranges of any of these towers in that entire book that you got? The prosecutor marked as exhibit. I don't have it. How about the 7 towers that he gave you as a summary? I don't know. Now, if you don't know the ranges, how can you say, and even if you do know the ranges, you can't say where exactly the handset was. Now, if you don't know where the ranges are, that evidence is completely irrelevant. It's not useful, okay? The handset will be in the range of the site indicated in the records. We can't get around that. That's the only way the call could have connected. But it will also be in range of other multiple sites, and there is no correlation between the closeness of the site used by the handset compared to the other sites within this range. Okay? So, what we've done so far to mount the defense, the handset was not your client's. The range was too large. The prosecutor doesn't even know the range. And now we're going to get into the factors that involve the choice of site with the handset. So we're going to debunk the idea that the handset connects with the closest site. That's our next step. Okay? Many factors affect the choice of cell site, not just distance. And these factors include, and this is how you do it. You would agree with me, Mr. or Ms. Expert, that many factors would affect the choice of cell site, not just distance. These factors include the following. You just roll down. Make and model of the phone, the wattage output of the phone, the generation of the phone, the bandwidth of the phone, whether it's indoor or outdoor call, urban or rural environment, topography of the area the site is located, location of the site, whether it was urban or rural, number of antennae on the site, height of the antennae on the sites, location of the antennae on the sites, direction of the antennae on the sites, range of the sites, weather conditions, angle of the antenna on the site, height of the site, how high the site is above the sea level, fractional percentage of channel assignments of the site, number of cell phone providers utilizing the site, number of cell phone providers within call region, performance of maintenance on the sites, wattage output of sites, and site traffic. Wouldn't you agree with me? I felt like Tom Waits with that song. You know, step right up. Yeah.
How come you don't have on there whether or not it's a prepaid phone? Didn't you say that doesn't?
Yeah, the fact that it's a prepaid phone or a contract phone only becomes relevant if the prosecutor tries to bring up that because it was a prepaid phone, it was a burner phone, so it was a drug dealer phone or a phone that's used by a criminal, a common criminal. And what you do is you use those statistics that I brought up earlier to say, hey, no, people get prepaid phones because they save money, and it is the fastest growing market. So you try and eliminate that out, that ability for them to make that argument, or even have that line of questioning.
Doesn't it affect the choice of cell site?
Well, right. And this is what happened. When I had a Sprint guy up there, he said, oh, no, Boost. You know, I just, out of curiosity, I wanted to know why my Boost phone wasn't working like my Sprint service. So I asked him, he said, oh, no, your Boost phone should connect with also. You know, so they don't really know. But the fact of the matter is, the phone is going to connect with a site. You have enough to go with over here, okay, to go ahead and show them that here are all the factors that affect the choice of site. Then the next question is, that you ask the expert is, are you aware of whether or not any of these things existed during the times of those calls? And they have to say no, because they don't know about any of this information, okay?
in your pretrial motion, the judge denied it because he ruled it wasn't scientific evidence, so Daubert doesn't apply, or did he rule that it met Daubert standards?
Okay, so the motion to order is actually in the PDFs. He just wanted to give it to me, so he just said that it's reliable evidence. And you know, the thing is that you present the same evidence to the jury. You've got a political appointee up there who's going to go ahead and do what the powers that be who put him there have dictated he should do. And you get common folk, the people who can't be corrupted, to go up there. You sell them on the same idea. What's that? Oh, really? You sell them on the same idea, and they got it. Okay? They're smart. They get it. Multiple factors may cause service interruptions. Cellular sites are designed to overlap to ensure coverage. If carrier calls drop, customers will change carriers. So what you do is you investigate the sites if you can. Okay? Urban cell sites may not be towers at all. We don't use the term tower because it conveys the image that it towers over its surroundings. Okay? Go past this. Okay, this is a great diagram that I use to demonstrate the strongest signal isn't necessarily the closest site. Okay, so what I do is I set up the easel. I put 5 dots. These are the cell sites. This is a person making the call with a handset. Okay? I say to the expert, okay, this one, let's assume that we're lining these up according to distance to the handset. Okay? Cell site number 1 is out of service. So which cell site would it go to? One. Number 2. Okay. Number 2. That cell site is handling the maximum number of calls. So where's it going to go? That cell site is obstructed. So where's it going to go? That cell site's antenna is facing the wrong direction. Where's it going to go? Strongest signal. You made your point. Okay? The government expert won't have information regarding the cell sites. So what I do is I analogize it to waiting in the bank. You ever wait in line at the bank? You don't go to the closest teller. You go to the next teller that's open, but everyone's waiting in that same line. Same concept with the handset. Okay? Now, this is called the false U-turn. Oh, it's not working. Snoop? Okay, so what I do is I set it up. Here's the easel. I draw a line, draw a divot this way, put a stick over there with the lines, put another stick over here, lines. Okay, and I say, let's assume that this is the arrangement for the coverage area, because what you do is you have a cell site over here that's going to cover all the area over here, and then there's a valley. So what the cell company does, they put another cell site over here that's going to incorporate the valleys. Okay? You have cell site 1, cell site 2. So if you looked at this record on paper, you would see 1, if you assume that the car is traveling in this direction, like we saw Snoop travel, you would see 1, 2, 1. Now, that could mean that Snoop is traveling in the same direction, or that could mean that Snoop pulled a Yui. Okay? Just based on the records alone, without having any further data. So you can show them that the records themselves are an inaccurate way of demonstrating where someone is. Okay, equidistant cell sites. Circle, handset, 1, 2, 3, 4. Okay? Simple diagram. If all sites are equidistant, that means equal distance to the handset. To which site will the handset connect? Pose that one to the expert and watch the left eyeball go into the right socket, and this is how it plays out. Let's go to the next example. We got the handset in the middle. We got 4 towers, and they're all equally distant to the handset. Which tower is the handset going to communicate with? He's got his stock answer, the one with the strongest signal. What happens if they're all 10 miles away and all things are equal? It would be the one that's providing the strongest signal. Can you tell me which one that might be? No, and this is a map of 5 dots. You can't. You have to have more information. Thank you very much. Okay. Assume that the handset is stationary. Okay? My handset is sitting on this table right here. Interesting point. The handset will connect with different sites, creating the illusion of movement. Because at different times, the factors are constantly changing while this call is connected. A strong wind will blow this way. Someone will open a door that way. The traffic on the particular site will change. And the expert must agree. And this is the proof to it. Okay? The assumed range of the sites may be greater than the communication potential of a handset. This looks complicated, but it really isn't. This is a combination of that first diagram with the area along with the equidistant cell sites, okay? We have the equidistant cell sites, we've got the handset, we've got the ranges of each cell site, okay? Now, this is what it's going to do. Assume they're omnidirectional, radius is 10 miles, equidistant sites, use the area of coverage, and look at that. This is really actually the only range of coverage that this handset's going to have. But you're going to get cell site records that are going to show it connected to this site, and you're not going to have, it's going to create the illusion that your guy could have been in this area here and not actually in this area. So again, it's not to prove, you're not trying to prove where the handset was. You're trying to demonstrate the inaccuracy of this evidence so the jury will just throw it out. Okay, this is a propagation map. What's wrong with this? Knowing what you know now so far, what's wrong with this? What this is trying to do is show you where the sites are and show you the borders here. What's wrong with this? Anyone?
It overemphasizes only one method that the phone is using to select towers.
Okay, pretty good. What this is doing here is it's showing clear borders as to the coverage area. What did we learn about coverage? They overlap, right. This is not true. But the prosecutor wants the jury to see this, to say, you leave one coverage area, you exit one, and you enter another. Okay? So how do you keep this out? You're not going to convince the judge about the science behind it. So you motion limine out, and this is what you really do. This is the argument you make. It doesn't reflect the sites at the time of the incident. Okay? So if you're in a jurisdiction where your cases go to trial 1-2 years later, they're not going to have the historic cell site locations for that 1 or 2 year period before. They're going to give you a map that's going to show the current one. That's the way you're going to keep it out, because the judge isn't going to agree with you for the scientific challenges, okay? Smart investigation, examine the assumptions, anticipate coverage area. So what happens here is, could I get 5 more minutes? Could I get 5?
Yes.
Okay, great. So I started getting these after I was litigating this with frequency in Connecticut. What the police are now doing is they're doing the mapping for you. So before, it was enough to just give you the historical cell site data, show that your guy was at the range of this site, and then your client sunk, and then you had lawyers pleading their guys out left and right. So I started making these challenges, and they said, you know what, we got to do one better. So now what they do is they create a map, and they create a range for you. And they say, see, that's where it was, that's where your guy was, that's where it took place, we know it's him. And that's it. Examine their assumptions here. Side to the south of the tower has a center line of 10 degrees and coverage area of 120 degrees, or 60 degrees to each side of the center line. How do they know that? I don't know how they know that. I think it's BS. When you get to cross-examination, you'll find that out. The tower appears to be a lucid tower. That is of no consequence. Cell phone towers generally have a coverage area of 70% overlap to the next closest tower. Well, you know what? Same police department just sent me discovery saying 30% overlap. So I can't wait to litigate that new case. I keep a dossier for myself. It would be consistent to say that the suspect's cell phone was inside the shaded area during this time. The shaded area depicts this 70% coverage area of side 2 of the tower. Okay? And then you show the other towers there. So here's the problem. I go ahead, I make a map here. Let's assume a 2-mile radius. Okay? This is a site utilized by the handset, and you see there's overlapping coverage with every single site that was on that map in the police report we just saw. And that is the area they mapped out. This is the 2-mile radius. So you see, they're just trying to pull one over on you. You go through this cross-exam like I just have done, and you'll be fine. Okay? Real-time location. Now, this is the way you wrap up your cross. And the jury's going to love this, man, okay? Increased accuracy, and you compare it to demonstrate the inaccuracy of site tracking to the finder of fact. What is real-time tracking? Real-time tracking is using GPS or actual real-time pinging off of a cell phone. What does that mean? Frequently, law enforcement, they're now getting court orders to go ahead and ping a phone, or tap into the GPS chip in a phone and locate that phone. That's real-time tracking, as opposed to what we just spoke about, which is historical data. You just get a whole bunch of cell phone records, and it shows you the cell sites that they connected to. They can't recreate real-time tracking. They can only do that now. So, location determination, handset accuracy, GPS chip in a phone can get you to approximately 50 feet. I've also had experts testify about 6 feet. Okay? And then there's something called trilateralization, where they measure the time that it takes for the phone to ping off of multiple cell sites. So you have a demonstration of this. We've got trilateralization, and then we've got the use of 2 different sites over here. All right, and this is how you end it. Not good enough for 911, not good enough for a conviction. The Wireless Communication Public Safety Act of '99 directed the FCC to make 911 the universal emergency number for all telephone services. Okay? Up to that point, there was really no ability for people to go ahead. There wasn't a uniform ability for people to contact emergency services with their phone by dialing 911. If you remember, I remember driving down highways, and it says for emergencies, there'd be a sign to contact state police. It'd be like star something, okay? Star and 2 digits, okay? This was a rule, a law that was passed to go ahead and make sure 911 you could dial from any cell phone and get emergency services. Now, the problem with that was, if you have a 911 hang up at a physical location at a landline, what happens? And it's a hang up. Okay? That location is immediately communicated to 911 dispatch. Even if you have an unpublished number or a block number, they have it. With 911 with a hang up on a cell phone, all they had was the cell site that the call connected to. And we know that that range is too big. So this was problematic for emergency services. Okay? So Enhanced 911, or E911 as it's called, automatically reports the telephone number and location of 911 calls made from cellular phones using a GPS location. So if you dial 911 and you hang up, they've got your actual GPS location, a latitude and longitude of where you're at. The Wireless Communication Public Safety Act of '99 required all cell phones manufactured after '96 to include a GPS chip. So all of our phones now have that GPS chip for emergency services. Even if you don't activate it when you're setting up your phone, you don't want it to communicate your location, that GPS chip will activate for 911 purposes. So how do you use this? I'm going to show you right now. This is how it plays out. This is me crossing. This is the end of my cross. I've gone through at this point with the expert. You don't know who had the phone. You don't know the ranges. We've gone through the diagrams. Now we're on to real-time tracking in GPS. Now, are you aware of any industries, right? Isn't it true that in private industries, when they're trying to determine locations, they use GPS? They use shipping industry. I don't work in shipping. Airplanes, correct? I don't work in the airplane industry. Daddy's trying to keep track of their daughters on their cell phones. I'm not a daddy, and I don't do that, he says. Are you aware of any industry whatsoever that uses purely cell phone towers to go ahead and locate objects or find proximity of objects? Any industry at all? I can speak in the cellular industry. We have. Okay, but if you're trying to locate the precise location, sometimes stenos get it wrong here. You keep track of that because they're only billing records, correct? Okay, for the U.S. government, they passed legislation. See, I'm making headway here, so now all of a sudden, objection to the form of the question. Counsel's testifying. Well, no, duh. It's cross-examination. That's what we do. It's cross. Overruled. Now, you see, this judge, he's a fair judge for Connecticut, but he's going to give the prosecutor, their day in court. He's interested now. Why? Because not only had I gained credibility with the jury, but now I gained credibility with this judge, and he wants to hear me go on because I'm entertaining him. The question is, and he finished it, the question is, the U.S. government set up, see, he wants me to ask that question. I'll rephrase it. I was going to strike it. When the U.S. government considered the importance of individuals being able to communicate with 911 operators, they abandoned, okay, here we go again, objection, assumes facts, not in evidence. We talked about 911 legislation at the beginning, Your Honor. Court, the way the government acted is obvious. They wanted to know where 911 calls were coming from, so overruled. Wow. Okay. And it wasn't good enough for the U.S. government. I'm sorry, what wasn't good enough? Objection again, calls for speculation in the conclusion. Court, enough, the answer is obvious, overruled. Question, it wasn't good enough for the U.S. government to just locate someone for 911 based on a cell tower, was it? Answer, I wasn't involved. I don't work for the U.S. government. I wasn't involved in the decision. I don't know. You know what? It doesn't matter. It's me testifying now. I don't care what he knows. Legislation was passed to ensure that each and every cell phone had a GPS chip in it so they could be located in an emergency telephone call, correct? Answer, I believe that's what they said, yes. Question, and that's to go ahead and protect every single person. I look at the jury. Every single person that has a cell phone to ensure their safety. And you look at the jury. The way I understand it, no. Great. The more cutesy answers you get, the better, because everyone knows this is true, even the judge. That expert is destroying himself. Calling 911 isn't a safety issue? Answer, you didn't mention calling 911, you just mentioned the safety of every person. Question, I talked about people with cell phone handsets that are now equipped with GPS to ensure E911 capability, okay? And that's to ensure the safety of every individual. You look over at the jury again, who owns a cell phone, right? Answer, well, isn't it to ensure that they can be located, right? I don't mean to be flippant with this question, okay? On any of these records, is there any evidence of the content of any conversations? No. Done. Okay? You've destroyed that expert, and you've destroyed this evidence. So, little trial tip. You know, the prosecutor saying, my client's agreed to a dismissal. Okay? And that's it, people. So, congratulations to the prosecutor. So, with the PDF documents, you can get sample subpoena to obtain cell phone records, transcripts from some of the cross and the direct experts, the motions that were filed both in federal court, state court, the opinions, list of contacts for cellular companies. So if anyone has any questions, please, feel free to call me at any time, and I will be glad to help you guys out. Okay? Take care.
Aaron Romano.
Can I introduce our panel now?
Yes, please.
Thank you. I don't need this, I don't think.
Yes, please.
These guys have come a long way. Norman got up this morning at 3:30. J.W. Coyle from Oklahoma City. Jack Gordon from Claremore, Oklahoma. We're missing our good friend Lawrence Martin, who's diagnosed with terminal cancer, and he's at home. So we're going to try to roll this and give you something that applies in every trial, Aaron. Every trial, Aaron. Voir dire, depending on the location you come from. So I want to get these guys up here and move this along so that you can go enjoy the rest of the day. But between these guys and yours truly, we probably have well in excess of 100 years of trial experience. 3 senior citizens and a kid. Where's my friend? EX? Where'd you go? Can you plug me in? I don't even know if we'll bother to get to it, but come if you would. We're going to try to skip the jokes. EX did this PowerPoint for me. I'll probably do it last so that you can hear these guys. This is real voir dire. Who wants to be first?